We got a problem, so.
You know, I've spoken to my client a little more about this ankle monitor issue, and I think we have to like kind of what happened.
We got a problem. I mean, they state that it was deactivated 4 months ago. And where is your monitor?
It's on my leg, sir.
But it's dead, right?
Yes, sir. It is.
It's charged, Your Honor. I think she's charged. It's charged, right? Or is it?
I've been trying.
No, he deactivated, so it doesn't matter.
Back in
She can get charged, she can use it as jewelry but it just doesn't do any purpose. It doesn't serve
I
any
think, Your Honor,
purpose.
she has, I'll let you know kind of what happened in that time period.
Yeah.
During
Can she speak, Your Honor? Explain what happened.
Yeah,
I've already talked to her.
this is your time because I'm about to make some orders that are going to affect your freedom. Go ahead.
4 months ago, I was pregnant. I ended up being in a relationship with somebody. I didn't know them that well. I do childhood, and whenever time I did that, I was getting away from something. I went there. It wasn't the best situation. I ended up getting pregnant during that time. That person beat me. He tried to sell me, like sex traffic me. I was fighting. He beat me with.
How is it somebody else's fault that you didn't pay for your ankle monitor? How is that somebody else's fault, man?
I was being held captive at the time, and I
For
basically
4 months you've been held captive?
I didn't.
This has been deactivated for 4 months. Nobody does that.
I literally had to scream outside the house for help in Dallas, Texas. You can look his name up. He's actually
Well, did you file on him for kidnapping?
Yes, sir.
What happened in the case?
Bruises. He's personally in jail right now because of this.
All right.
I have bruises there.
Once again, but for 4 months, you haven't had a device that you were supposed to have. And that's your problem. You're charged with deadly conduct here. And there was a good reason that we made sure that we wanted to know where you were. And this happened where?
The incident or with this?
Yes. The incident, no, that you said that this person.
Dallas. I went to Houston with him.
What are you doing in Dallas?
He took me all the way to Dallas, and he took all my.
What are you doing in Houston?
That's what I was trying to explain.
See, that's why we have these devices, so we know where you are at all times.
Yes, sir. And during that time, basically, he took all access to everything. I basically had to stand outside the house and
You made a choice of who to pal up with.
You're right.
That's your problem.
I left that situation. And so I was getting back. And I just never had a chance to pay. But I can pay the days. And not only that, I don't have no issue. My only thing is
You got a big issue.
I didn't do it.
You got a big issue on this order of the court.
I'm just trying to get past this. I can't go to, I don't want to go to, I don't know.
That's where you're headed. I mean, that's where you go when you don't follow the orders of the court. For 4 months, my goodness. I didn't know about this.
And the only reason why you put it on me just to make sure I wasn't late for court. I didn't show up for court and I showed up for court. That was the only reason why you put it on me. I never been in trouble before. I ain't run.
It doesn't matter. The court can for good cause, any good cause, order bond conditions.
Yes, sir.
But what you've told me is you decide when the bond conditions and what bond conditions are going to be followed. Not me, and I'm supposed to be the one setting it. But for 4 months, you have been violating a condition of bond, and then we kind of stumble upon it because we have so many cases. We can't be watching everybody. We have to trust that they're going to follow the rules. And sometimes it happens where you a day or two, and then there's no harm done. But we're talking about 4 months,
and I still followed.
And then you're getting involved in criminal issues in other counties.
No, I didn't get involved in criminal issues.
You were part of something that was, you said, you want to just continue to just interrupt me through this whole thing. It sounds like you're the kind of person though that kind of bullies your way into your way. You want it on your terms, and And when you don't have it on your terms, then you interrupt and you make excuses, but the bar is set for everybody and they have to get over the bar. And you hadn't been over the bar in 4 months. And that was something that you had an obligation to tell me as much as the bondsman did. But you haven't been following a condition of bond for 4 months, my goodness. That's serious. Very serious. And what we normally do in the cases like this is your bond is revoked. You're in jail and we'll sit this out until we can dispose of this case. That's what happens in all the cases. Sorry, but you had a chance. I have to be able to trust you and I don't. This is a big gap of a problem.
I think, Your Honor, the argument she's trying to make.
We're talking about a crime of violence that you've been charged with.
It's no.
Well, you're presumed innocent, but the grand jury says there's probable cause to believe you did. Because of that, I have to rely on that as a probable situation. So that's why bond conditions are set. And that's all we're talking about.
Your Honor, I think the issue was because she got involved with someone who ended up being in a very violent, bad situation, who got taken kind
I'm talking about 4 months not telling me about.
Well,
that's what we're talking about.
Well, she just recently got free, and that so she was kind of held for him for a while. So
No, when I can see that for 4 months she's been she's been kidnapped for 4 months, let me know. But I haven't read about that in the paper, and that would make the news. Don't tell me that you hadn't in 4 months been had time. And John, here's what we'll do is I'll give you a hearing on it and y'all can produce witnesses, but until then, it defies logic that she has been held captive for 4 months. And so I want to see some proof of that.
We'll get that.
All right. All right.
We can be in custody for now. So
Your bond is revoked. Yes, because you hadn't had a monitor on it. You hadn't called me about it and talked to us. And it was deactivated a long time ago. That's your responsibility.
I don't.
It's a condition of bond and you must have that or you're not released You must have that, but I've already, you're going to interrupt me all day long. Is that what it is? Boy, that's rude.
No, sir.
I mean, if there was a crime for that, you'd be guilty of that one because you interrupt. Anyway, that's what I'm going to do, John, is those findings and see what y'all, I don't know what y'all plan to do in the disposition, but you can have some time, talk to her before we send her.
Absolutely.
Away. But I've got to have some conditions that, so we know that she's supervised and you're not being supervised by the court. And that's what you're supposed to be. And you were on your own supervision, which is not the way it works. All right. Well, let me know. Thanks, John. We're here for business. Okay. Who else?
Thank you very much. We call 2239851, the state of Texas versus Renisha Bassard, who's present with her attorney, Mr. West, and the state's attorney. What do we, I don't have anything.
I'm trying to get it to you, Judge.
Okay.
Batteries are dead on every one of these tablets.
Oh, boy.
This is one.
I know, we're meeting with them tomorrow to go over battery stuff.
Well, people aren't plugging them into when they leave here.
Well, that's all.
2239851 is called. Does the defendant who's present with her attorney waive a formal reading of the indictment and the arraignment here? Can we proceed as such?
Yes, Your Honor.
In summary, this indictment alleges that on or about April 15th, 2022 in Jefferson County, Texas, you committed the third-degree felony of deadly conduct. Do you understand what you're charged with here?
Yes, sir.
Yes. If convicted, you face no less than 2 nor more than 10 years
Yes,
confinement in prison, and a fine up to $10,000 can be assessed for any third-degree felony. Do you understand?
Yes.
An agreement has been reached in this case. Can you read that into the records?
Yes, Your Honor. The agreement is a cap of 6 years.
6 years.
Yes, sir.
All right. So we're looking at, no less than 2, no more than 6 years in
Right.
prison.
Or probation, deferred probation. I think she's open to all of them.
Deferred or unadjudicated probation up to 10 years. What about regular
I
probation?
think she's eligible for regular probation too. She doesn't have a.
I can't remember. This is kind of a weird one, isn't it?
It's deadly conduct with
On deadly,
the firearm, isn't it?
yeah, I know, but didn't we
If it
have?
has a deadly weapon attached to it, can it be? It's 3G.
I don't.
Can't remember. On this-
It says Article 42A53 does not apply to defendant when the show that a deadly weapon is defined was used or exhibited during the commission of felony offense. And the defendant used or exhibited a deadly weapon. So that's on the law parties that wouldn't be.
Okay.
So 42A054, looking at subsection B.
Hold on, so, there was something weird about this in the past, the statute, but. Okay, fine.
Under subsection B, it says does not apply to a defendant when it's shown that a deadly weapon was used or exhibited during the commission of a felony offense or immediate flight therefrom. And then number 2 says, and the defendant used or exhibited the deadly weapon.
Mhm.
And so this is not a law of parties. This is, we're accusing her of doing this.
All right, well,
Yes.
No, it's just weird that it wasn't. I guess it didn't, it wasn't specifically
Stated in it.
enumerated
Right.
in the numerical sequence of crimes. Didn't we have?
Because
I
there's,
thought we dealt with this issue one time and we had a bunch of disagreement over it, but it clearly says any offense involving where the use of a deadly weapon, I mean, it wouldn't make sense. It wouldn't apply. The elements of deadly conduct certainly seem to be
all right in there.
no less serious than
Because in the guidance.
a deadly weapon
No, we discharge a firearm.
was used or exhibited.
I guess there are ways on deadly conduct that you could recklessly engage in conduct that places another in imminent danger or serious bodily injury without using a deadly weapon.
Right.
So it's only if there's allegation of a firearm and that they use and exhibited one, a deadly weapon.
I think there's other ways to get deadly conduct without getting a deadly weapon. Which doesn't make sense.
All right, so it looks like those are the only 2 options. Deferred or unadjudicated.
2-6.
An agreement has been reached. Again, where whatever sentence shall not exceed a cap of 6 years in prison. And is that your understanding of the agreement? If I follow this, you have no right of appeal of your case. Do you understand? How do you plead to this indictment charging you with the 3rd-degree felony of deadly conduct, guilty or not guilty?
Not guilty. I mean guilty.
You got to pick one.
Not guilty. I mean, sorry, guilty.
What's your, think about it, relax. Okay, what is it you're gonna plead? You've pled not guilty twice.
I have to plead guilty, so you there's me today.
Are you guilty or not guilty? That's the question.
You are paid.
Okay, all right. Well, that's okay. Yeah, you can't force you into this. All
I'm
right.
guilty. I mean guilty. Sorry.
Oh, no, this is,
Judge, I
I'm
don't,
guilty. I didn't understand the question. Sorry.
what did you want to say, Mr. Lane?
just since she's pled not guilty twice, I just wanted to make sure she had time to think about it, not just make a rash
Yeah, I
decision.
thought there was a decision made and we were over lunch.
Yes, sir.
and
Right.
Then
Just
came
getting
back.
over it. Sorry.
Yes,
ma'am.
I'm guilty.
Okay.
I'm positive. I'm so sure. Judge Stevens. Sorry about the thing wrong.
So how do you plead then?
Guilty.
Is that your final answer? Are you pleading guilty voluntarily and because you are indeed guilty of what this alleges?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1. And did you sign that
Yes, sir.
voluntarily?
Yes, sir.
Understand it, discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. Indictment's been read to you. You've read it. And you've thought about it and you are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial, the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived?
Yes, Your Honor, I think.
Okay, I want everybody to
If that's
sound in on this.
Yeah.
What?
okay. Yes, Your Honor, I think she wants to move forward today and not do a PSI.
Okay, go ahead.
Your Honor, I would request in this case, my client give deferred probation. Some of the reasons why is that she has no criminal record. She had this, I think she has some pending misdemeanor charges that may be related to this or sometimes after that, but it's not. She has no convictions for that. So the fact that she has a clean record, this was a disagreement regarding her her child's father, however you want to describe him. She apparently had a dispute with him. A gun became involved. She had a gun for her protection. And then somewhere along the way, there was a shot fired. Luckily no one was hit with the shot. She has been cooperative in court, even though, like I said, this morning we had an issue regarding the ankle monitor. She was here to be on court on time here, didn't have any issues there. And I think I'm looking at here, the other misdemeanor is pending as a evading arrest or detention. I think when the cops got there, she did take off running from them. Or I'm not sure that the fact that I know she was charged with evading arrest and detention as part of this offense. Your Honor, this is the case where we were here this morning and her bond was revoked. She, at that point, said she wouldn't have taken the deal. We were kind of working on a negotiating a deal on this. And we were going to reset it for just a little more time to negotiate a little further to try to get her. I was going to request it from the state probation. And I think that's why Mr. Laird did offer the cap, whereas they were not going to agree to probation, but they were giving her the ability to get probation from the court. And we just asked the court to give her probation and whatever conditions the court thinks are required to make her successful.
Okay. State.
Judge, the problem I have with all that is the use of a deadly weapon. You know how this county is just turning into just one place after another where everybody's using a gun and nobody ever settles their fights with words or anything else. I'm trying to remember. I mean, there was a lot of things going on out there. It looked like there were a bunch of people, but witnesses all backed up to the complainant in this case that she also had her children in the truck and pointed it at a group of people. And I think she actually fired one shot at the group. When they got to her, she had 3 outstanding city warrants, of course.
How'd she miss the group? We can't hear what you're saying.
I never shot, I never had a gun. I asked them right there to test me for gunpowder residue. They didn't. And they had cameras and everything, and the police even said they didn't see nothing. The only people who said that I shot was his recent girlfriend and his childhood best friend. I was in the car. Everybody else can testify and said that I stayed right by our apartment. The incident happened right by the park. I never had a gun. I promise, Mother Great, I'm gonna pass away.
Well, then how did we get to,
Shot fired.
how did we get to this charge if you didn't have a gun?
You know,
Well, but you just pled guilty under oath saying you had a gun, that you threatened these people with firearms.
You're in a catch-22. I mean, this is what the crime is that you do. And you knowingly discharged a firearm at in the direction of a person. And that's one of the elements of this crime. That's a problem. You either admit it or you don't. And if you don't, so we're
If you didn't
we're
do it,
kind of
now it's time
impasse.
to fight.
I didn't do it. I didn't shoot again. I promise.
Okay, well, we can't go forward with this. All right. All right, well, then, what we'll do is, well, the bond is revoked. And I told you what the bond is, and it's gonna be doubled and she'll be held in custody, but all we can do is put this up for trial as soon as possible and set it for trial. Whatever, everybody says.
I can disagree. You disagree, just the probation. I just don't want to go to jail. I really don't. I agree with it. I just don't want to go to jail. If I could just steal probation, I accept all the penalties. Yes, please. But I think I just didn't shoot again. I didn't shoot again. I didn't shoot again. I asked him right there to text for gunpowder residue. It's everything, even the police, like the cameras, all of that.
I'll look at it, Judge. I promise I'll look at it really hard. I promise.
Well, I mean, but of course, the only other thing is a no contest plea,
Please, no contest. Yeah, that's what I want to do. No contest.
but they gotta agree. with it.
Now, here's the problem with that is, if you're honestly saying you didn't do it, okay, that's what's gonna be, because nobody else has told you this. If you mess up on your probation letter, you can't come back and say, I didn't do it, you'll go to prison, okay? You could go to prison on mess up, well, you say that now, but there's a lot of things that can trip you up.
I'm gonna try my hardest.
So- If you did not do this, now's the time to say that, and I can look at it, I'll look at it again and talk to people, we'll see. I don't want to take a no contest plea, because you really seem adamant about the fact you didn't do it.
But I also don't want to sit in jail. So I get the sterilization. I sit right here and take.
Right now, that you can't enter the plea. The state doesn't agree to it. So we have a bond issue that's got to get dealt with, so.
Yeah, I already had him, I know somebody following him on,
I do not.
notice on, request to respond. I'll file that soon, and we have him on here.
All right, but right now the bond is revoked and
Prepared yet.
for
Yeah.
failure to maintain the bond condition of having a GPS device as required. But I can bring her back, you know, next week or
Every week.
whenever, when y'all, as soon as y'all can figure
I
something
think
out.
except for the week of July 4th, this I'm not here.
All right,
I have,
that is all.
I have number 2 that's coming Monday next door,
Okay.
but that'll be at 1:00, so Monday morning.
Okay.
I'll say guilty. I just don't want to go to jail. Can I do that right now?
No, you can't do it now. You've already said enough. You kind of put yourself in a bad position. You can,
I'm sorry.
all right, what's next?
Come on, go.
Should have learned. Before I go back there.
We treat you like we treat everybody else. You don't have a GPS device for 4 months, you kind of lose your bond. Mr. Wilkerson,
He's back.
it's what?
This client, he's filling out the last set of people.
I've got one done.